What about Twitter? I think Twitter is an enormously powerful tool for lawyers. It's a powerful marketing tool. It's a powerful networking tool. It's a powerful research tool. For lawyers in solo and small practices, it can be a kind of a virtual water cooler. I wrote an article a couple of years ago called Tweet 16, 16 ways lawyers can use Twitter. You can find that on my blog, lawsitesblog.com. But from an ethical point of view, what I hear most commonly expressed about Twitter is that lawyers who use it run the risk of inadvertently forming attorney-client relationships, or that lawyers who use it run the risk of being seen as inappropriately soliciting clients. I don't see it on either account. Here is another area where I think the ABA 2020 Commission really gets it right when they talk about the rule on the rule on forming attorney-client relationships. They've proposed a change to Rule 1.18 that would change the rule from what it now says. The rule now says a person who discusses with a lawyer the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. Their proposed change would say a person who discusses, or rather a person who communicates with a lawyer about the possibility of forming a client-lawyer relationship and has a reasonable expectation that the lawyer is willing to consider forming a client-lawyer relationship with respect to a matter is a prospective client. I think a lawyer has to be aggressively misusing Twitter to even get near the danger zone with regard to attorney-client relationships or solicitation. Again, with the solicitation rule requires a lawyer to be communicating with somebody, attempting to engage them for pecuniary gain. I don't see that with Twitter in anything that I've seen going on Twitter. And I think a lawyer would really be having to overstep and abusing his or her use of Twitter for there to be any ethical concern whatsoever.